Okay, good morning. Thank you for coming to the Kingsville Community Center. My name's Tamara Stomp, and I'd like to ask you to beware of bearing gifts. So I want to talk about a simple fact situation. Say your daughter's going to get married, but it could be your son. So just reverse these examples if need be. You've heard that her and her betrothed are planning on buying a house. You want to give them $20,000 as a down payment towards the house. And you find this beautiful wedding gift card. And you write a lovely endorsement with your congratulations on it and great hopes for the future for them. And you address the card to both of them. But you enclose a $20,000 check that's only made payable to your daughter, your bloodkin. And then on the line of the check, that reline, you say, for your new house together. Okay. That is called a law school question. And you get to probably write a dissertation on how that is going to play out. I'm here to just give you some clues about the legal and practical ramifications of your good intentions of giving such a gift to your blood relative. There are many ways to look at this from a legal point of view, so we're going to talk about some of them. But short and sweet, it's highly likely that this will be deemed to be a gift to both your daughter and the son-in-law, even though the check's only made out to the daughter. This means that they're each equally entitled to the money, and since it's a gift, they're not required to give it back. So if you come on hard times, you just lost $20,000 that you might need back from them. They might have to gift it back to you if they would, but I'm sure they'll have spent it. So of course we hope that they live happily ever after. I remember watching Disney, and all movies end with the couple riding off into the sunset happily ever after. And now as a family law lawyer, I know that that's not exactly the way it works at all. So if your daughter and your son-in-law lived happily ever after, you would have no problem with giving them that money and have no objection to it ever. But with the divorce rates at 50%, they say, in the US say 60%, it's likely that they'll separate somewhere along the line. We are now doing divorces for people who have been together for 6 months, or for 1 year, 2 years, 5 years. And we're doing second and third divorces for people, and I've had 1/4, that hopeless romantic couple. But you've got to plan ahead for things financially in this modern time. So hopefully they separate after you get the grandchildren that you've wanted. But sooner or later, when you actually think about it, you will feel like you were being taken advantage of when you gave that $20,000. You extended it, even though you should have probably, in my view, and that's my best advice, is to keep it for yourself so that you can invest it because you worked hard to get it. You'll be so shocked when your daughter and son-in-law take off to Disney with the kids and don't invite you, but then you're back there working part-time at Walmart to supplement your pension and saving for them. So the worst, of course, case scenario is something like, when this actually happens, it's perhaps your son-in-law, and again, I can reverse this and say this could be your daughter-in-law, starts doing a lot of drugs, uses up all the money on the drugs, and never buys the house. And then your daughter, or your son-in-law, decides that that partner's not for them, and they're going to separate, and and they're going to have an affair, because their husband's or wife is always out doing drugs with other people, so they have an affair and they start a separation. However way it works out, and there's a million ways. People always ask me, how do I get separated? And I say, I don't know, pick, whatever, which way it works out. But what will happen is that if there's a house, the house will be sold. When the house is sold, it's called a matrimonial home under family law, and it has a special designation. And it's because the legal title might be in one person's name, the wife or the husband, and it might be in joint names. And different things can happen to it, and there's different consequences to it, depending upon whose name it's in. So when that house is sold, if it's joint, the money gets split. If it's sole, then the money, technically, it belongs to the person who's the legal owner. But because the Family Law Act says that matrimonial home is such a special thing, that the other person gets a part of that, the half of that in the payoff of the equalization of the net family property between the parties. So you can see then that this card, being very non-committal as to whether or not it was a gift or a loan, has many things to argue about. My suggestion is that you figure this out ahead of time, what you want to happen, what should happen, what you hope happens. Be very clear about it in your gift, and then you'll know what the consequences are in the end and have to live with them. And that's the best way to do it instead of unknowing. People do not want to pay lawyers for advice. My recommendation is that you do, because it can avoid a lot of heartache and thinking. Can you imagine all the nights you lay awake wondering, what about this, and what about this, what about this, and what about this, and if this happened, that happened? Just go find a lawyer, and most of us will tell you flat out what it is in your particular situation. So what happens to the money? Is it a loan or a gift? So on my experience of 41 years in the court, there's some interpretation on that fact situation, because the money was only made out to the daughter, even though it said it was a gift for both. And that could have some consequences that are arguable, but I would think that a judge would say it's for both. So lesson number one is give out the gift to the real recipient that you want to have it, and leave the words to whisper in her ear as you hug her after you give it, after she thanks you for it, or he thanks you for it. Do not need to advertise it in a card or something else. I don't believe a gift is a good idea to give, because a gift means it's totally theirs. And I bet you probably wanted it to go towards that house. $20,000 is a lot of money, and you didn't want to spend it on a Disney trip. So, or maybe you do if they take the kids and you along, but you certainly don't want to spend it on a Las Vegas trip. And all they did was drink and blow it gambling. So what you probably want to do is make sure that it's a loan. And if it's a loan, then to me, that means that you have a little bit more control over it, but then steps in the bank. So what happens is that the young couple goes to the bank and says, do I qualify for a loan? And they say, okay, let's go through, and you've probably already done this on your own. They ask you what you have, money you have coming in, and what you spend it on. And they have percentages. Probably from somewhere in Toronto on high, there's some people sitting in a boardroom that have nothing to do with your life, deciding whether or not you can afford, because of the percentages, you can afford a mortgage of this much or that much. And what they'll ask you is how much money you're already paying out on your debt. And you usually want the couple to consolidate the debt and wrap it into the mortgage, which only means it gets paid off over a longer period of time. But that's what they want, because they only want you to pay attention to their debt and not default on it. The best case scenario is to write out that $20,000 gift as a loan. And the format that's being used by most of the lawyers is a promissory note. However, I can tell you that I've had people write out just handwritten notes, and it worked in court. But I can tell you there's one judge in Windsor that it never works for. He wants it all be legal and all stamped and dutied up and all these fancy words in it. The bearer shall thus and therefore and ifers that and all. And I just like plain language, and I know exactly what the intention was, so I want to there's two parts to law. One is that what it actually reads, and the other is the intention, and we usually argue over which wins out. So it's the intention. You can tell that this came from a family member as a gift to do something particular, like buy the house. The promissory note just reads, it's a demand note. You may have seen them already, but it can be also written out by hand to the other 7 judges who will accept it, not that one. And it'll just say this promissory note is given to mom and dad from such and such for $20,000, and there's no interest unless there'll be interest at 5% on demand per year or something like that. And you're never demanding it because it was virtually a gift, but when you have to demand it, which is usually in a separation, then the interest kicks in and then the payments kick in. And the more detailed it is, the more the judges like it as a true obligation of a loan, and that it's not masking as a gift. But then what turns around is that the bank says, nope, nope, if you have that loan that you have to pay back, then you've got too much money to pay back, so we're not even going to give you a mortgage because you can't afford our big mortgage when you've got this car payment, you've got $20,000 of credit cards were rolling in, but you also have this loan to your grandparents or parents, and we're not going to say that you qualify because you don't have enough money in the envelope. So, disposable income in the envelope, net at the end of the day after you pay all your expenses, because they'll give you so much for hydro and utilities and all that stuff. And good gosh, if you throw in a first marriage with 2 kids to support, you're paying there, and the second kid, two kids you're paying support there, you got a big, huge support payment, you're never going to be able to afford this. So the gift is why a lot of people say, well, I got to give it to them as a gift because they can't get the mortgage otherwise, because the bank is requiring that it be written out as a gift, not as a loan. And I think that's completely unfair, and that's where the activism has to happen. If you're never demanding it, if legally you don't have to demand it, then it shouldn't be counted as something that you have to be in your payables column and count against you. And I understand what they're saying is that the giftor or the loaner can ask that a promissory note is payable back on demand, so they could demand it any time. But what if it said, only if you separate? Then there's a condition to it. And if you separate, then the house will be sold, or someone will buy each other out, and will also take care of the money that was attached to the house, being this loan. So I don't know why the banks aren't satisfied with that. I've talked to a couple real estate lawyers, because this is where it happens, and they say that, they just want it, nothing cleared, it has to be a gift. It cannot be a loan. So people fudge the loan paper, try to find a way to word it, and then you end up in court, and that's the argument in court that you have to pay the lawyer a lot of money for. I say see the lawyer beforehand so you don't have to pay a lot of money. Same reason you go get a prenup, so that you don't have to argue about it later, because it's all in the prenuptial agreement, and you don't have it up in the air. So hands down all the way around, I think it should be a loan because it's your money. You could have saved that in your own pocket for your own retirement. Because here I see that, and this has happened recently, if you see people who have sold the house on the most recent market a month and a half ago, they made tons and tons of money on it, they kept the proceeds, and you're still working at Walmart part-time to supplement your retirement income, and you can't afford to go into an old age home. So I say keep your money, and then just give them gifts every once in a while. $100 here when they come to visit you, $100 there. Buy your daughter some clothes, buy your son, if he's down to only $3,000 on his car loan and you want him to clear it for the next refinancing, then give him the $3,000 then. But the big, big, big sums of money, or too many small sums of money that add up to big, are what you should watch out for. And remember, when I give you this advice, I'm acting now like pretending like I'm your lawyer, and I'm giving advice for you, not for your kid. not for the recipient of the money. I'm trying to protect you. That's my job, is to be hired by you, is to protect you. And today, I'm trying to do that with this little discussion. So, there's some distinctions that have to be made because a whole body of law has been built up about this. And it all depends upon the fact situation, as most legal situations do, and the law that's applied. And then to me, it also depends upon who your judge is and who your lawyers are arguing. And then the people have to get up and testify. So if they can express themselves well, they're better. I always tell them, go watch TV shows and learn how to talk when you're on the stand. You're going to have a terrible time. And most people just don't want to have the whole problem of going to court and dragging, little old ladies out of the nursing home to come in and talk about the gift that they gave 25 years ago. It's not a great idea. So it's best to have it resolved in the beginning. So let's talk about what happens when you separate. This is only when you separate. When everybody's happy, there's no problem, okay? But when separation, what kicks in is the Family Law Act, and you deal with 5 things. Custody, which is now called decision-making responsibility. And then there was access or visitation, which means now it's a new term called parenting time. And then there's child support, spousal support, and the equalization of family property. 5 big categories. In the equalization of family property, we're talking about this one small category. Equalization means that you add up all your assets, you minus all your debts, you have certain deductions for premarital and for inheritances, and then whatever each of your columns add up to, that is called your net family property. And what you do is you take you see if there's a difference in the columns. So that when you walk out of the marriage and you have the separation complete, you should be having equal. So if one person has more and the other has less, you take the difference between the two, divide it in half, and whoever has more pays the half to the other one, and now you'll have it equal. So in other words, husband has 100, wife has 50. There's a difference of $50 between the two of them. Divide the 50 in half, take 50 from the person who has more, give it to the person who has less. Now they both have 75. Thus, you have equalized the net of the family property that existed on the date of separation. It is not what was all there throughout the marriage. It's not just what you came into the marriage with. It's not any of those. It's just what is in existence on the date of separation, applying all these interesting rules. So the net family property has some other rules that it talks about of excluded property that's excluded from the net family property calculation. And one of them is property other than the matrimonial home, because it has such a special place in the law, that if it was a gift or inheritance from a third person that was acquired after the date of marriage, that will be excluded. But there's a trick. It's only if you keep it in a separate bank account. It's only if you invest it in a separate, say, a vehicle, and the vehicle's only in your name, and say the wife got the money from you, used it to buy a car, it was a total gift. If it's her gift and she doesn't meld it in with the family property, then you could probably get away with it being hers and not being counted in the calculations of the net family property. Another one is damages from personal injury accidents, as long as you keep them separate. A lot of people get their damages from a personal injury accident while they're married. 5 years later, they separate, and it's already been spent on repairs on the matrimonial home, which is in joint names. Blown, and you don't get it counted because it doesn't exist on the date of separation. And there's other stuff, which is one, the property that the spouses that have agreed to by a domestic contract, like a prenuptial agreement, like a marriage contract, that wouldn't be included in the spouse's net family property. If you do one of those, and I highly recommend them for second marriages, even though you may feel like you don't have a lot of money, that you have left, that little bit of money you have left is precious when you're older. So you're actually making sure that if there's money in the bank, that is not going to be split 50-50. if you separate. So there's a whole new set of rules for common law. Some of them overlap a bit, but common law, remember, does not mean that you're married. That's a dirty rumor going around that it does. It never did. I mean, I had a guy come in one time and said, well, I've been living together with the girl for 15 days, so aren't I entitled to half of the furniture? Where's the furniture? In the apartment. So they don't even have money enough to buy a house, but 15 days, no. You leave with the stuff you came in with. What did you come in with? The shirt off my back and a bag of clothes, then that's what you leave with. Well, you're not very helpful, Tamara Stomp. I don't like you as a lawyer, I'm leaving. Sir, no problem. But so common law just means that you're back to the old principles of legal analysis, which whose legal title is it in? So a lot of people think, well, I've been living with this guy for 20 years and I've had 5 kids with him and I stayed home and I let him be the one who went out and worked and had a great career, and now we're separating. I got nothing. I got no pension. I got nothing to fall back on, and we were going to live off his pension and we were going to go to Florida every winter. That might not happen, except that there is a relief called the constructive trust argument. And with that argument, it's totally different than in a marriage situation. In a marriage situation for property, it's 50-50, no ifs and buts about it. There's a small exception. But no ifs and buts about it, it's pretty well 50-50. In common law, now you got to pay me as your lawyer to argue whether it's 1% or 2% or 5% or I had a judge say 37.5%. Where'd you come up with that? Why didn't you just round it off to 40 or take it down to 35? But you know, all the way up to 49%. They can pick a number out of a hat and choose that one. And you're paying me to argue which number it is, which is really just a pick. It's supposed to have a lot of validity, but how do you measure worth into a house? I'm the one who put up those curtains. I painted that wall, but you know, he put in the kitchen cupboards, and I helped with the landscape. He put in the landscaping of the trees, but I put in the flowers and I tended to them. How do you value all that stuff in the worth of a matrimonial home? It's very, very hard to argue out in front of a judge. So although a lot of young people just want to live together common law, once they start acquiring assets, they have to get in writing, or they will be faced with this common law argument. So what we're going to do is a couple examples here, and I'm going to hope that you can see this. You might not be able to from that far back. So we're going to do the net family property statement and show you how these things make a difference. So I'm going to make a column for the husband and a column for the wife. It could be common law or whatever if you're applying that, and I'm just picking that. So what I said was that you add up all the assets. Then you minus all the debts. Then you take account probably of premarital property. And the other one was inheritances, which gets a bit complicated. So we'll just talk about this first. So first of all, I wrote out a little bit of easy adding here. So, because if I was really good at math, I would have been an accountant. Okay, so assets is a house. So I'm talking about the net of the house. But if it's 100, I'm putting 100 here, but put like comma 3 zeros on everything here, okay? But 100, that means 50 for each, right? $50 for each. And if you have a car, I'm going to say that the husband goes to work, so his car, he took the little crappy car to work, and she got a better car because she's got to drive the kids around to hockey and everything. And an RSP, he's got more income to be able to put in about $30,000, and she's only got about $10,000 with a spousal opportunity there, and maybe he's lucky enough to have a pension. Those are going the way of the dodo, so there's only a few places you can get those. Encourage your kids to go to university for that kind of job. And the pensions for him. So when you add up everything on this side, he's got $120,000 of net, and she's got $80,000. But they have some credit cards, and we'll say there's 20 in his name, because he's been going out after work a lot. And she's only got 10 in her name. And so when you add that up, you do 120 minus 20, and you're down to 100. 80 minus 10, you're down to 70. See the difference? What's the difference? 30? And you divide that by 2, equals 15. The person who has more, take 15 away from that. You're now down to 85. You put 15 over here onto 70. You both have 85. Thus, you have equalized the net family property. Easy peasy, right? Okay, they're all harder than that. So let's talk about some variations here. What if you did give a gift? So if the gift was made during marriage, it would go in the asset column to the daughter, and she has a gift there to add on of about $20,000. And she never did end up she kept it separate in a bank account. Well, then that means that this gift can then come out at the bottom, can be hers if it was before marriage, which I recommend. If it's before marriage, then it turns into a premarital gift. Okay, so then that comes out here at the bottom before these things now. We're going to have this problem here. So if it's a gift, it comes in, it goes in because you have to list everything that you have. You can't hide anything. You got to be clear on everything that you have. And then it becomes 100. But, so she only takes away 10, she's got 80. But she's going to take another 20 away from there. So she's down to, what is that, 65. So this is the sloppiest writing I've ever seen because I'm trying to do it sideways and then speak to you as well. I apologize. So her column now adds up to 100. She'll take 10 off for the credit cards, and she'll take 20 off for the gift, for premarital gift, which is 30. So that's 30 off of the 100. So now she's down to 70 again. It didn't count. It didn't count because it was a gift that she got before marriage and she kept it separate. She will kick herself if she put it into the house, which is what most people do. That's why they got the gift, right? But if she was lucky enough to do that, then that was good. The next, so premarital gifts are okay. They go in and out. Premarital is anything that you had on the day that you got married. So it could be an RSP, it could be money in the bank, it could be a vehicle. So what you have to do is you have to go through the black book of used cars in Canada to find out what a 1974 Ford was worth in 1980 when you got married, and then you still had it when separated in 2010. And then you have to plug in all those numbers. That's what the lawyers help with. You have to go to your RSP and say, you got to look up all my old records. And I'll tell you, the problem is the banks don't want to look up the old records. They don't want their staff spending time on it. They don't even want to keep those records. They'll tell you that they've all disappeared now that they're computerized. So you really should be keeping all your records all along. But there is another way to do that, which is that before you get married, you take all your records into a lawyer. The lawyer writes out an affidavit that you swear it's true. We staple it all to the back, and when you separate 20, 30 years later, you look at it and go, here's all my proof of what I had when I came into the marriage. Ta-da, done. You didn't have to pay any more money for a lawyer. It was done for a small little interview at the time when it was all fresh in your mind and your statements were all available. Nobody does that, and I think it's the greatest service a lawyer can do for you. And I try to get people to do that, but nobody wants to do that when they're just about to get married because they're happy. They don't want to think about a separation. And I think you need to. You have to ask them to. Anyway, so what happens if this is a gift that was given after marriage? Well, the only time it works, again, is if you've kept it separate after marriage. It's from a third person, and you put it in a separate bank account, and you hold it there. And you'll only do that when you get a gift when you're older. When you're younger, you need it to live off of. So it'll probably be disappeared if you have your kids young and at home. But later, if you get an inheritance or a gift, you're more likely to a gift before the person passes away, a relative passes away, or an inheritance after they pass away. Then if you keep it separate and still in the bank account because you don't need it right then it'll go in and it'll come out again. So what we're really worried about, in my view, is the loan part. And that's where here the loan is what I think you want to say that the bank won't let you. And if you put in a loan, say it was 20,000 and it was to both of the people, then it's 10 and 10. Once there's the equal amount on each side, it cancels each other out in the whole calculation. So it'll still be this 70, and the numbers will be higher, but the bottom line will be just that much less, but it'll still be equal. So this was 70 here originally, and now it's going to be 20 that comes off instead of 10, and 20 that comes off instead of 10 is the total, and 30 that comes off. So now it's 120 minus 30 is 90 instead of that, and 70 minus not 10 but 20 is 50, and you end up with the difference of 40. Why am I doing my math wrong?
50, 70, 80 on top.
I'm at 80 up here, right? Okay. Minus 20, 60. And then you still have the 30 divided by 2, and you get 15 each. What happens, though, is if the loan is only made to one person, then the whole of the 20 goes over here. But the loan now makes it lopsided so that this is still 100. And the loan over here makes this 30, right? And now it's 70 divided by 2, which is still 30. Wait, again, my math. 80 minus 30 is 50. We're down again. So 100, and the difference from 50 is now 50 divided by 2, which makes it 25. So you feel like you've saved that, but someone still has to pay the loan if it's really a loan that has to be paid. But if it was a loan that is now gifted to you because you're separated, you now gift it to your daughter because you're separated and really didn't want it back, then your daughter is $25,000 ahead to pay for a new place to live in with her and the 10 kids. Otherwise, she has to live with you, right? So you really want to give it to her. So that doesn't happen. So there's a lot of practical consequences as well as legal ones. The loan can often be, and then the other thing that you might want is that the loan to be classified up here as something that both of the people admit has to be paid off. Both of the partners admit has to be paid off. It was a real true loan. And if it's a real true loan, then you should use the profit from the house to pay it off and get your money right up front back. Why are you making it come through your daughter? But the judges are so tough on that one, I have to say. So right off the top, this comes down with a $20,000 loan. This comes down to 80, and there's 40-40. The characterization in the end will be the same because it's equal, but at least you got your money back when you were supposed to. So that's why I like the loan that's only payable upon sale of the house. And a sale, it should say the word transfer of the house, because a sale means it's usually to a third party, or you sell it to your other spouse, or transfer it for some sort of interest elsewhere. Like if that was all just on one side and one person was keeping the house, it would lopside it out. So I don't know if that completely confused you, but it's only a mathematical calculation, so that when judges say, but I know you built the house yourself, and you and your father, but your father volunteered his time, and but my dad should get paid for those hours that he put into the house. Well, he didn't ask for pay before. No. Well, you can't ask for it now that it's just separated. So if you want to do up a bill for your labor, put that on a bill that's owed if the house ever gets sold to anybody other than your daughter. See, there's things that I think people haven't been told to think ahead about, and so they should actually think about it so that they can plan it for the future, because there's just a lot of separations. People don't put up with abusive marriages or unhappy situations anymore, and they shouldn't. They shouldn't. Everybody's entitled to a nice life. You know, I used to apologize that I was a divorce lawyer. It's like I did something wrong. No, I had nothing to do with this separation. You know, I wasn't in it at all. I met you afterwards. And so it's not my fault. I'm just trying to fix it so that it's livable afterwards. So there's your there's a little bit of everything in that, hopefully. And can speak to you if you have any questions. Yes, ma'am.
If you have a house that you want to put in your children's name before you die or whatever, is that wise, or is it better just to wait until you're gone?
Well, I guess what you do is you make it joint. I think the real estate lawyers will, and estates lawyers, not me, I'm a family lawyer, but I've seen enough of it, is you put it in joint names so that the survivor gets it without taxes. Because if you don't pay taxes on a transfer of a house if it's a matrimonial home. It's your primary, the way it says it in the Tax Act is primary residence. So you don't pay tax on that, but if it's an extra house, you get capital gains tax, right? But you're actually wanting to, are you just giving it to one or both? Yeah, when you're giving it to a couple, you got this problem again when they separate. So how do you work that? Do you keep it in your name till the very end and hope that they stay together before then? Because, it's really convenient if you just died. And I don't mean to be rude about that, but if you just died, then you wouldn't have those bad feelings about how you gave it to them and they frittered it away, or she had to give him half in a separation later, because you're dead. You can't think about it. You're just having fun upstairs there, and I'm way upstairs, I'm talking. And seriously, so many people want to plan for what happens after they die, and really, you're not around to see any of it happen. So make it as clean as you possibly can, because one thing you don't want is for there to be continuous arguments. Same thing happens with life insurance all the time. People say, well, I want my life insurance to be left to whoever I choose. Well, that usually means your new partner that you're sleeping with. You don't want anybody to get your life insurance, to profit from your death by life insurance, which is the way I call it, if they're not sleeping with you when you pass away, right? So it's got to be the new woman that they want life insurance for. But the judges say if you've still got children or spousal support to pay, you have to designate the life insurance as security for the support in case you're dead and you can't go to work. Then you don't collect a paycheck and you don't have an income stream. And when you don't have an income stream, then you aren't liable for child or spousal support. Child support, they can both bind your estate, but what often happens is, to ensure that all the estate hasn't gone to the new girlfriend, they bind it up by saying that you designate the life insurance policy, and the person who gets the ex-wife gets the life insurance and just pretends she's paying herself out $650 a month from whatever that life insurance is, and doesn't bother going through the courts to sue for any more money. To bind up the estate. And usually what will happen is that person who's on the second relationship will make sure that they've done a will that gives everything to someone else. Their new squeeze is who they're going to give it to. Their new partner, their new person. So don't count on it being left for the kids even, because the new person, and sometimes the new person's kids, end up with it more than the person who passed away originally. So I would say that I would stay on title if you want control. So you and the two of them, you could be a 50% common law, 50% tenants in common each, the two of them and you. And tenants in common does not give a right of survivorship. A joint tenancy on the deed gives a right of survivorship, and that's where the tax planning comes in. It becomes given to whoever survives. So you might want a three-way go at it, and then you've had some control while you're still alive, after you're dead. We don't know what goes on. Yes, ma'am, at the back. Okay. I didn't hear the first part very well, but pretending you're getting an inheritance and you want to give some of that.
Giving them part
No?
of what they would get after you died ahead of time, before, to live in.
I still didn't understand it. What did you say?
We're just giving them.
Oh, yours right now. So that's what I talked about, was a gift versus a loan. Okay, that's the one thing. So, and you asked, and I wanted to make another point, and you asked something about how do you protect it? Yeah, okay, that's what we were talking about. Who are you protecting it from? Are you protecting it from your daughter, and therefore you only want her to be able to dip into it? I'm assuming it's the daughter. But,
Single from the CRA, I'm thinking.
oh, CRA, that's right.
He has to pay taxes because it's an income, not income.
Yeah, it is not an income, it's a gift. Okay? So CRA doesn't go around and look in all of our different bank accounts to see what pops up in there every once in a while. Believe me, they can't even catch the big criminals. So they're not going to come around to most little people unless you somehow flag it. But when she gets the 50 in her name, she will then presumably save it and make interest off of it. And the interest is income. So she'll get a T5 for which you have to report on your Tax Canada. You can't avoid taxes and death. Those are the two things, right? So, but that's her baby. That's she's got it now. You've given your gift and you've done the best you could. Either you pay the taxes on it with the T5, or you can give it to her and she can pay taxes on the lower income that she might have. If she's got a higher income than you, it doesn't make any sense at all to send it to somebody who's making higher taxes. But, you know, possible. You just still want to be generous and give a gift, you know. So the best gift is to give a gift that goes into their TFSA, right? There's no taxes on a TFSA. No interest. Interest accrued does not have taxes. It does not get a T5. Great government of Canada doing that for you. Yes, sir.
If you want to finance your child, go straight to the grandchild.
Yeah.
You know, what are the implications there? What do we face there? What issues do we have? You know?
So I think you said if you want to bypass a child and go straight to the grandchild, the question is, how old is the grandchild? If it's under 18, then you probably don't want to give money to a 2-year-old. They can't sign the papers at the bank for it. You know, 8, 9, 10, 11, that's not going to happen. They can have a bank account, but you the bank will require that there'll be someone holding it in trust. So you may as well hold it in your own account for them, unless you want to avoid that tax thing. You could make a trust and start to accumulate money for them, and the interest stays in the trust, and they don't get it until a certain age. And the question becomes, even when they're 18 and they're entitled to it by law, that you may make a trust or an arrangement that keeps your name on the. It's like if you just put in a bank account, if you put it in a bank account, they'll want an adult's name on it. And you'll keep that. You won't just fly off of that after they're 18. So you'll stay on that maybe till they're 40. Who knows? And then you have control over how it goes in and out. But that it'll go on their tax return, because they do collect taxes from kids who are younger than 18 if they make income. So what you're looking to find out, though, is what is the age that you're ready to give it to this child. And that's why I say keep control of it, because you don't know if this is going to be a really great kid who keeps all their money and is really frugal and already knows how to invest better than anybody else in the world by the time they're 20. Or maybe they're, took their money, they can't wait till the money that you've told them, I put away. Yeah, and this is what I got to tell you. Don't tell them I put away money for you, that's yours. Don't tell them that. Make it a surprise in the end. Because we have so many parents who come to us and say, the kids say, well, you got that money put away for me, so I want it now. Oh, why do you want it? And before you know it, they bought a Porsche and they're driving on the sand in Las Vegas, in California. Is that what you wanted that for? I don't think so. So you can save in a separate account for them, an in-trust account, and you'll have all the same, reporting. T4s will come to you for any interest on it. You can invest on their behalf. You can lose it on their behalf in a bad market, and you can gain it in a good market on their behalf. Same rules go. But you have to decide when you're ready to pass away, you have to decide when it is that you're ready to give this over into a vehicle that they can have. And some people tell me their kids aren't even grown up yet and they're 35, 40. So you have to decide what you want, your money. You're actually giving them what's called an early inheritance, but there's no such thing as an early inheritance because an inheritance only happens when you're dead. Okay? But remember, a power of attorney is when you're alive. The will is what governs when you're dead. So, but for passing on stuff, it's gifts and it's loans. Or you hold somehow control over that money with your name on the account. Does that help?
Yeah, I was actually more thinking if we both passed early and then you're leaving, could we just jump past the children to, I have a daughter who's not mentally well, and her daughter's father, I was just wondering if he intervened with the money that I left for the granddaughter.
Okay, so there's many combinations of ways to do it. First of all, your children are going to be so pissed if you jump generations, right? So talk about starting in a family argument, that'll be it. Depending how young the children are, if the children are young, then the parent will still probably be the one to be in control, unless you gave it to some person they don't even know, and they'll wonder why they have to go to this person to ask for help to get little, grandchild Johnny through university because grandparents have both passed away, and this guy you don't even know you have to talk to and beg for that money. And you have to decide whether you want that to happen or if you just want to give it to them and hope that they're doing the best that they can by their children, just like you plan to do yours. And remember, these days, it's really hard to do. I know it was hard for our generation, or there's some people here a little bit older than me. It was hard enough for our generation to work hard and save money. And now the kids can't even get a job. And we got them university educations that we paid for out of our pocket, and they still can't get a decent job, and they can't get the pension jobs, So it's a whole different landscape out there that you have to think about. Yeah, Miss?
Just a question. I have a house, my son has a house. He wanted to buy a second one and didn't have the credit just by him. So I put my name in, so we owe one together. If he should get in trouble, could he get everything mine too?
Okay, I'm not sure I got that exactly, but there are two houses in both names, or yours is in your own name,
Yeah, and his is on his name.
but you had to co-sign for him?
No.
Oh.
But also another house bought.
Oh, at third house.
Yeah, and that house is both of our names. And if he should get in trouble somehow, somewhere, would this house, I don't help pay
Yeah.
him, he pays it himself.
Okay, so you need to talk to the real estate lawyer who did that deal for you, where you got post put on there. But my inclination, not being a real estate lawyer, but my inclination is to think that if you were tenants in common, then as on the deed, then you would not necessarily be as liable for losing that third house, except by but by joint tenancy, it would attach to the whole of the house, any debt that he comes up with. But you might be talking about him having a wild party and someone dies there and he gets sued, and can they come after you? Yes, because your name's on the property, and yes, you could lose your other property. The answer is yes. Okay. So you got to think of these things. You got to think these out along the lines of it, right? Yes.
Going back to that gentleman wanting to give it to the grandkids, a friend of mine, her father died. He had left investments to her and her husband and her two children, and his whole estate he left to the grandchildren. So they put it in a trust for the children, and he designated them to have it at 20 William Street.
Mm-hmm. And they're
For schooling and for
yeah.
specifically for those
Yep.
kids.
That's what you would do. You would set up a trust, yeah, and have someone else as part of it. Either you trust your children or to give it to their grandchildren, or you have to go for somebody completely different. In the old days, they actually hired lawyers to do that. I don't know too many lawyers that are on family deals like that. I think a lot of the lawyers are on business deals still, But I don't do any of that type of law, and I don't want to be on your family deal. Man, I got problems alone with my family on my own, thank you. I don't need yours into it. And, you know, for a personal thing to have to do with. And there's extra reporting to the Law Society, extra accounting stuff that I might not be interested in. Trying to simplify my life as well. So, anything else? Well, I hope I've given you some clue of things to watch out for, but some clue of questions to ask when you go to make further purchases, when you go to make further investments, and when you go to talk about your will, you're going to ask these same questions to your estates lawyer, who really is up on the up-to-date stuff. Remember, I'm only dealing with people who are separated, and I don't want you to be disappointed and lose your life savings that you thought were going to your daughter or your son, and they end up going elsewhere. So beware of bearing gifts.
Thank you, Tamara.